Welcome back. We are following this breaking news out of Florida, where the jury has reached a verdict in the double murder trial for the defendant, the one we've been showing you throughout this week, the one who's unmistakable because of the skeleton tattoos that are on his face. The jury has made a decision in his case.
His name, Wade Wilson, and he's accused of murdering 2 women in 2019. He allegedly confessed to the murders to his father.
Let's get you back into that courtroom for the verdict, where the jury is present.
The jury, my understanding is we have reached a verdict. All right, do you have the verdict form? All right, we pass that to the bailiff. The verdict form appears to be in order. I'll have the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit, in Lee County, Florida, criminal action. State of Florida versus Wade Wilson. Case number 19 CF 0568. Verdict. We, the jury, finds as follow as to the defendant in this case. Count 1, first-degree murder, Christine Melton. The defendant is guilty of first-degree murder. Count 2, grand theft motor vehicle. The defendant is guilty of grand theft motor vehicle. Count 3, battery. The defendant is guilty of battery. Count 4, first-degree murder, Diane Ruiz. The defendant is guilty of first-degree murder. Count 5, burglary of dwelling. The defendant is guilty of burglary of a dwelling. Count 6, first-degree petty theft. The defendant is guilty of first-degree petty theft. Dated 6/12/24, so say we all, 4-person.
All right, does either party wish to have the jury polled?
Yes, please.
All right. Just my number.
All right, we just heard the verdict in that case, and as it was being read, we did not see any emotion from the defendant in this case, Wade Wilson. We saw some camera shots over there for the people that were in the gallery. You could see that they grabbed each other when that first guilty verdict was read on Christine Melton. Why don't we bring in our guest to discuss what's happening in this case as we just received this verdict, criminal defense attorney and former district attorney Matthew Mangino. Matthew, really no surprise here. We did see defense counsel trying to get jurors to think that this could be second-degree murder, arguing that there was no premeditation here. What are your thoughts?
Well, I agree. This is no surprise. I mean, the jury deliberated for 2 hours, and it's guilty across the board. I mean, this is a defendant who bragged about killing these women. His own father testified about him bragging about the manner in which he killed these women. In fact, he said something to the effect that, you know, he ran over one of the victims with his car so many times that she looked like spaghetti. You know, so this is not somebody that jurors are going to feel, you know, sympathetic toward and say, well, oh yeah, he's under the influence of drugs and that's why he did it. You know, that's not really much of a defense, trying to say that it wasn't premeditated. You know, it's not an insanity defense. They made that clear. And so it really lacks any substance in terms of a defense, and that's why the jury came back so quickly.
Yeah, really the substance of this defense will be for this penalty phase that is coming. These jurors, they are not done with their service. We understand that the court is going to take a week-long break in between this guilt phase and the penalty phase. Matthew Mangino, your thoughts on what is going to be on the table when this penalty phase begins?
Just leave everything here. Sorry.
Well, you know, the prosecution is going to move forward with this jury who's been death qualified. So each one of these jurors have said they could impose the death penalty if the law requires it. they're going to prove aggravating circumstances that exist in this case and why he should be sentenced to the death penalty. The defense is going to have to put on mitigation. They're going to have to put on mitigating factors to try
Matthew,
to
I hate
offset
to cut you
the
off.
aggravating factors.
We have the judge speaking to the jury, so we need to go back in. Stand by.
Like the jury's exited the courtroom. All right, so procedurally, I wanted to find out from the parties what their preference was at this point towards scheduling and what to tell them as far as when to come back. I know we talked about it previously. I just want to make sure.
Judge, I would ask that we have them back here at 9 a.m. on Thursday for the penalty phase proceeding of next week.
Okay, and are you requesting the court to adjudicate at this time?
Yes.
Okay.
I
Anything
agree with scheduling 9 o'clock Thursday morning.
Thursday morning is not going to be possible, you don't think, to start on Wednesday?
No, I have one professional scheduled here on Friday. I have another one Monday and Tuesday.
Okay.
A third one Tuesday, and then obviously the state has the opportunity.
Okay, fair, that's fine.
And we anticipate 1 to 2 days, so for sure
Okay.
2 days at the most.
All right. Same with the defense?
agree.
Okay. So I'm going to bring them back in, and I'll give them the same instruction regarding not discussing anything or any of that, or looking up anything, any of that regards, and then come back at 9 a.m. As for, let me see the verdict form, please. Mr. Wilson, as the jury has found you guilty as charged under each count under the indictment, I do adjudicate you guilty of first-degree murder of Christine Melton. I adjudicate you guilty of grand theft motor vehicle. I adjudicate you guilty of battery. I adjudicate you guilty of first-degree murder of Diane Ruiz. And I adjudicate you guilty of burglary of a dwelling. And I adjudicate you guilty of first-degree petty theft. We'll bring the jury back in. I'll tell them to come back next Thursday. We'll bring them in.
Judge, they would also like to have certified copies of Mr. Wilson's fingerprints taken at this time.
We'll do that after.
Thank you, Judge.
The justice for these two women in this conviction. Matthew Mangino, I cut you off earlier, but I wanted you to pick back up where you were talking about those mitigators, because we heard the defense say they are going to put on witnesses, something they didn't do in the penalty phase, in the guilt phase, rather.
Right. So this case now, Julia, is all about trying to save his life, trying to prevent the death penalty. And the way that the defense has to do that is by presenting mitigating evidence and, reasons why, he shouldn't get the death penalty. It might deal with mental health. It might deal with his upbringing. It might deal with, his family, any issues that he's had that can be presented to have the jury impose life without parole.
Yeah, let's go back into court.
What we call the guilt phase of the proceedings, it's now time to schedule what will be called the penalty phase. I previously instructed you on that when we first started. You were under the same orders I previously gave in terms of not doing any research, not looking up anything, discussing anything about this case with anyone, including close family members, and even among yourselves at this point. Your deliberations are complete, but we're going to have you come back for the penalty phase to do not discuss anything else at this point, even among yourselves, and like I said, with anyone else. Don't watch local news television. Don't read any local newspapers. Stay away from any kind of internet articles or anything else regarding this case. Does everybody understand those instructions? All right. Can everybody follow those instructions? All right. So we will have you come back. We expect the next phase to take place next Thursday and Friday. And so we would have you come back next Thursday morning at 9 a.m. That is June the 20th at 9 a.m. And the bailiff will show you where to meet for that. So remember those instructions and come back June 20th at 9 a.m. You may go.
You are watching live coverage of the verdict that was just reached in the case here we've been watching at Court TV in Florida. Florida versus Wade Wilson, guilty on every single count.
And in 1 week, this same jury is going to come back and decide life in prison without parole or the death penalty. The judge now giving the final words to these parties.
I know the state has requested fingerprints, and so we'll do that. Do we need 2 sets?
Yes, Judge.
Okay. All right. Any legal objections to that?
No.
Okay. Anything the court needs to address prior to recessing until next Thursday?
It's our understanding, and I think the court's aware then, that the 2 alternates would also be instructed to come back Thursday. They'd sit as part of the penalty proceeding and then step in if need be.
That's correct. So we will have to contact them and have them come back Thursday at 9 a.m. as well on June 20th. And I know you said you thought you might have some objection to that, but was that true?
Objection to that? No.
Okay. All right.
No, that's fine. I had filed a motion with regard to payment of my mitigation expert for lodging and the like. That's pending. I haven't heard from JAC yet. I'm going to go ahead and send you an order.
Okay.
And then we'll just deal with it.
Okay.
Thank you.
Any other matters the court needs to address?
No, Your Honor. I have a
Yes.
question. As far as the evidence,
Yes.
will we need it for next week?
Yes.
Yes.
Yeah, bring all that back, and also I have the bailiff collect all the notebooks back there and bring them to me. And then I think they would start with new notebooks for the penalty phase. I don't know that they would use these notebooks. I'm not sure. We have to look into that between now and Thursday.
Yeah.
But I'll collect them and I'll hold them until next Thursday.
I think they can use them, but we'll look into it.
Okay. Any other matters?
No.
Okay. All right then. Mr. Wilson, you'll get fingerprinted, and we'll see you back here next Thursday, June 20th at 9 a.m. I'm going to have to move that screen.
This court is remanding Mr. Wilson to the custody of the sheriff's office.
Yes, and Mr. Wilson will be remanded to the custody of the sheriff and be held without bond.
Thank you, Your Honor.
We're going to bring back in Matthew Mangino just to talk about, as we keep these live pictures up, Wade Wilson guilty on all charges. Matthew, can you kind of talk with us a little bit bigger picture? You see cases like this, and a lot of people think the evidence was so against him. Of course this man is guilty. Why do we waste taxpayer dollars going to trial like this when it was clear this man was guilty? In this case, the prosecutor was asked by the judge, did you offer him any reduced penalties, any reduced charges? She said, absolutely not. You've been a criminal defense attorney for a while. What do you do with that? You have to go to trial. People might say in the public, okay, it's clear he's guilty, and his defense counsel even said that. We're not saying he didn't do this. Can you kind of talk about that?
Yeah, that's interesting, and it happens when the prosecution has a good case. Here, they had a great case. They had his own words. They had his confessions, his joking about it, his nonchalance about the whole process. So they're not going to offer any plea bargain. They want the death penalty in this case. And I've tried cases myself, and most recently is last fall, where the prosecution refused to offer a plea bargain. It was first-degree murder. We had argued that it was, in the heat of passion, and ultimately were successful in that argument. But in this case, hey, go to trial, and that's all you're entitled to.
And I wonder how much of a hard line these prosecutors had, and many, especially in Florida, where you've had a lot of scrutiny of the death penalty law there, and the way now it's changed in terms of, do you need all of the jurors? Do you need some of the jurors, a majority of the jurors, in order to find for death, and whether they refuse to take it off the table, forcing their hand and having to at least go through this process to get to the penalty phase. But I have a question, Matthew, about how his attorneys may address, we've talked about it a lot just because you can't ignore it when you see his face, the fact that these tattoos that he has on his face, that he got them after this killing. He's now a convicted killer. But is that something, including there are some tattoos that are very offensive. They are racial epithets, essentially, on his face. Is that something that they should address in their actual case? Should they explain perhaps what he's been going through and his affiliations now that he is behind bars? Or do you ignore it and not say anything about it because these jurors have already been vetted that they won't hold it against him?
Well, yeah, that's an interesting point, and we know that some of those markings on his face espouse hate. Swastika on his face, something that happened after the murder. So we certainly don't see him backing away from being a violent person. I think just like in any other case, the defense might want to take that on in some way and say what, the trauma that he's gone through since he's been in prison, whatever that might be, rather than just leave that issue open to the prosecution to say, hey, look at his face, look at these markings. This isn't a guy who's remorseful. This isn't a guy who acknowledges responsibility necessarily. This is a guy filled with hate, and make him a good candidate for the death penalty.
Yeah, I would think that'd probably be that kind of decision, especially when they take a look at the father's testimony or what he said, and we'll see that probably again in the penalty phase about the father saying he felt that his son would do it again.
And that was a powerful witness, but also he could talk about his childhood and perhaps even what his son went through. So we may see him return to the stand.